Association. Thank you, Justice Donnelly, for being here today to hold this discussion.
Thank you very much, Domenica. It's a pleasure to be here. Thank you for your help in organizing this presentation. I've been looking forward to this for months. I also want to thank everyone who tuned in. I understand that we're near 115 participants today, so I'm glad to see such interest in such an important topic that is near and dear to my heart and I'm very passionate about. Um, so we've assembled an excellent group of experts that you're going to learn from today in this CLE. But before I get to the introductions, I want to attempt to put in context the problem of wrongful conviction in our system and the status quo. As each and every one of the participants know on this call, the criminal justice system exists to resolve criminal accusations brought by the government for unlawful conduct. And in spite of the many safeguards that we're fortunate to have in this country to protect people who are accused of crimes, namely the presumption of innocence and the right to counsel and a right to have your case heard before a jury, uh, the fact is the system unfortunately doesn't often provide absolute 100% certainty. And the safeguards that exist after a conviction occurs in which someone maintains their innocence simply, I believe you'll come to the understanding, are inadequate to deal with the problem of preventing wrongful conviction on the front end of the system and then providing a remedy as soon as possible once that occurs. Appellate courts are not adequate, in my opinion, in addressing the injustice of innocence. It is perfectly acceptable in our system for a trial to occur in which the prosecutor, acting in 100% good faith in his or her belief in the theory of guilt they are presenting to the jury, presents that case. A defense lawyer zealously represents their client, protecting their rights and casting doubt upon the theory of the case, a neutral judge, and still produce an incorrect and false result, leading to a wrongful conviction. And as proof of that, one simply needs to look at the statistics gathered at the National Registry of Exoneration. For everyone's edification, the first DNA exoneration in this country took place in 1989. And prior to that fact or that incident occurring, in our country's history, there were just close to 400 actual exonerations on record prior to that. According to the statistics I took a look at this morning, we are now hovering at 4,000 people who have been exonerated since that first 1989 exoneration, and that amounts to a total of 34,800 years of having people incarcerated for crimes that they did not commit. And I'm sure in many of those crimes, as I mentioned earlier, the prosecutors were acting under theories of guilt that they believed were had good faith beliefs in the theory of guilt that they were presenting. It's so we're going to talk about some reforms, given the fact that these shortcomings exist in our system today. I do want to alert everyone that we're going to put a news story that just occurred in the New York Times in the chat for you to see, that I think is Exhibit A, that exemplifies the problem, and it identifies an individual in Nassau County who was identified through the advancements of DNA as the perpetrator in a terrible, awful crime that occurred in 1984, in which a young victim was murdered and raped. And he is now, fortunately, in custody, facing prosecution with the DNA results that seem to basically identify him as the true perpetrator. In this particular case, 3 other men earlier were the subject of the prosecution of the same crime that this man is now convicted of, and they served 17 years for the crime that he is now alleged to have committed. There's no connection between the three of them. They were eventually exonerated when their DNA excluded them, and the state paid out nearly $54 million in compensation for the years that they will never get back. So today we are going to explore what alternatives exist, mainly focusing on the subject of conviction integrity units, how they are working in other parts of the country, what are considered the best practices, and we've assembled an excellent panel of experts in this subject area. I'm going to go in order of their presentations real quick and just have them introduce themselves to you and identify who they are and what they will be speaking to during their presentations over the course of the next hour. And we will have opportunities for you to present questions to each of the panelists and myself. So you can simply put those in the chat, and Domenica will be monitoring that. So we're going to start with Ms. Marissa Bluestein, the Assistant Director of the Quattrone Center in Philadelphia for the Administration of Justice. If you could please introduce yourself and let the folks on the Zoom know what you're going to be addressing during your presentation.
Sure. Thank you, Mr. Justice, and good afternoon, everyone. My name is Marissa Bluestein. I am an Assistant Director of the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Carey Law School in Philadelphia. And my work here at the Quattrone Center is working with particularly prosecutors and innocence lawyers around the country to help them adhere to best practices, particularly in relation to what we are known as conviction integrity units or conviction review units, which are small units within a prosecutor's office is dedicated to looking at and identifying wrongful convictions. So that's the work that we do here. Before that, I was at the Pennsylvania Innocence Project for about 10 years, looking to identify cases of wrongful conviction within Pennsylvania, and that work brought me to the Quattrone Center, where I've been for about 6 years.
Thank you very much for being here. And next, I'd like to introduce Mr. John Holloway, Senior Advisor at the Quattrone Center for the Administration of Justice. If you could please introduce yourself to the participants today.
Yeah, thanks, Justice Donnelly, and thanks, Domenica and everybody for having us on this panel and the opportunity to talk about this topic. I'm John Holloway. I'm a colleague of Marissa's at the Quattrone Center. We started the Quattrone Center in 2013 with the idea being, looking at the trends that Justice Donnelly referenced, that we could create a research and policy center that would learn from these wrongful convictions and try to apply that knowledge forward to prevent future wrongful convictions from happening. And at the time, conviction integrity units were just kind of becoming a thing. There were about 25 of them across the country. And we did a study that we published in 2016 that was an in-depth survey of 21 of the first 25 across the country, because there was some skepticism about whether or not conviction integrity units were a thing that could be done. Would it be possible for a prosecutor's office to have a unit within its offices that reviewed its own cases when there were plausible claims of actual innocence? And so we wanted to try to find out, whether we really had the fox guarding the hen house, or whether such an endeavor could actually be done successfully and in good faith. And we wanted to help. If you had a unit, we wanted to help you, as Marissa is now doing with her work, to incorporate best practices. And if you didn't have a unit, we wanted you to figure out how to create one. And then the third constituency we were trying to help was the defense bar in the community, to differentiate between a good faith unit really trying to do some fairly complex and important work, and a smoke and mirrors unit that was being done for PR purposes. And so we published that report in 2016 and have been working with units ever since. My specific work often is to, and we're actually working and going to publish one, I think, in the next couple months, with once there's been an exoneration, looking at that case and trying to identify the contributing factors that led to an outcome that nobody wanted. As you said, Justice Donnelly, we often find that the prosecutors didn't want this to happen. Certainly the defense attorneys didn't want it to happen. The jurors or the judges don't want that to happen. So we looked at the contributing factors that the system provides that might lead to errors, and then we work with jurisdictions to implement those fixes in the future. So you can kind of think of a conviction integrity unit as an ongoing quality improvement engine for not just the prosecutor's office, but the entire judicial system, criminal justice system in that jurisdiction.
All right, thank you very much for being here, John. Next, I'd like to introduce Ms. Kim Corral. You're identified in your caption as a criminal defense attorney, but I'm going to address you because this seminar is called Prosecuting Innocence as an Innocence Advocate, because as I've told many students, I believe that that's a perception that hampers innocence advocates for when you're representing people who claim innocence. You're really not defending anything. You're prosecuting a case of innocence, and you bear the burden of proof. Please introduce yourself to the attendees and tell us a little bit about what you're going to be addressing today.
Thank you, Justice Donnelly. I'm Kimberly Kendall Corral, and I have a small firm in Cleveland that does a range of criminal defense from investigation to trial level. But the primary lion's share of our workload is wrongful conviction cases and innocence claims. And so I'm going to be sharing with this group my experiences, both personal and professional, handling those claims. And we've handled those through conviction integrity units, through traditional litigation, and through clemency requests, and any kind of creative procedure we can sort of fed out along the way.
All right, thank you very much for being here. And finally, last but not least, Mr. Matthew Ahn, Attorney Matthew Ahn from the Ohio Justice and Policy Center, former professor. Please introduce yourselves and tell us what you're going to be addressing this afternoon.
Thank you, Justice Donnelly. My name is Matthew Ahn. I am currently the director of the Beyond Guilt Project at the Ohio Justice and Policy Center. And so my current role, we actually deal with post-conviction relief for folks who do not claim innocence. But in that role, we do try to and strive to work directly with prosecutors' offices on questions of miscarriages of justice for folks who have been incarcerated for long periods of time. Now, I have spent most of my law practice career as a post-conviction and appeals defense attorney. So questions of innocence and claims of innocence come up frequently. In addition, I did run for Cuyahoga County prosecutor in 2024. One of the major issues in the campaign was sort of how to best approach claims of innocence and claims of wrongful conviction from the perspective of a prosecutor's office.
All right, thank you very much for being here. We're going to start with the individual presentations. So I'm going to turn it off to you, Ms. Bluestein, if you can please present, and I know you have some slides to present about your subject matter. Thank you.
There we go. Yes, I do. It's not a Zoom webinar until somebody forgets to take the mute off. So as I said, we work with conviction integrity units around the country. And John mentioned a 2016 report that he put out through the Quattrone Center. We actually are putting the finishing touches on a follow-up to that, where we actually did surveys in 2021 and 2023. So we'll have some updated data for you on that in this presentation. But let's starting with a baseline definition that a CIU, or conviction review unit, conviction integrity unit, post-conviction justice unit, these units carry a lot of different names, but they have the same agenda and the same mission, which is that it's an organization within the prosecutor's office conducting extrajudicial fact-based review of secured convictions to investigate plausible allegations of actual innocence. And by extrajudicial, we simply mean that there is no pending appeal or post-conviction matter in the courts, and that somebody reaches out to a conviction integrity unit, or a lawyer on behalf of somebody reaches out to a conviction integrity unit and asks them to conduct an investigation on a secured conviction because there's proof, allegations, or that the individual who was convicted was either wrongly convicted and that they shouldn't have been convicted due to constitutional or procedural error, or that they are actually innocent. And these are units within offices all around the country. So to date, by our count, there are about 135 conviction integrity units around the country, including several in Ohio. Some of them are within state attorneys general offices, where they provide services for the entire state, as in Minnesota, Pennsylvania, Illinois, and other states. So if there are smaller counties within the state that don't have the resources to be able to provide that kind of work, that's where the Attorney General's office can kind of step in. As you can see, there's still some states where there are no conviction integrity units of which we know, but we do work with most of these units all around the country on a regular basis. When we look at CIU participation in exonerations, as Justice Donnelly said in the beginning, the National Registry of Exonerations tracks all exonerations in the United States and tries to record every one. An exoneration being a case where somebody was convicted and then their conviction is vacated on the basis of evidence of actual innocence, and they're either retried and acquitted, or all charges are dismissed because of that. When you look at the participation of conviction integrity units within those, you can see that it's been a pretty steady upswing since about 2012, which is when we really started to see a large jump in the number of units across the country. Last year, again, according to the National Registry of Exonerations, there were 147 total exonerations across the United States. 93 of those involved either a conviction integrity unit or an innocence organization. In Ohio, the Public Defender's Office has an innocence organization, as well as, of course, the Ohio Innocence Project. And so there are 62 exonerations from conviction integrity units, 53 from innocence organizations, and then 22 what we call joint exonerations, where those units or organizations actually worked together to try to free somebody that they believe to be actually innocent. So I will touch on this in a bit. We don't like to use exonerations as any kind of sole metric of success, just because there's so many factors that lead to exonerations, most of which is luck, that the evidence has to be available for testing, people have to be willing to participate and speak with you and maybe admit that they did testify incorrectly at trial, or new evidence comes up about an actual perpetrator. That notwithstanding, we do still have a sense of the number of exonerations throughout. Now you can see that in Harris County, Texas, last year there were 17 exonerations, which is quite larger than any other. Those were because those were group exonerations around drug cases in Harris County, and they're now nearing the end of that review, as I understand, but there have been dozens of individuals who are exonerated because of that scandal. And then the others, you see Philadelphia has 8, Los Angeles 6, and then we have 4, 4, 3, and then 2 and 1 from other units. As I said, we don't like to use exonerations as the sole metric of success. We look for other things, like John was saying at the top. Is this unit a sincere unit, or is it one which is engaging in kind of a public relations exercise? So some of the things that we look for in legitimacy is, are they an independent unit? Is the unit outside of the appellate practice within the prosecutor's office, outside of the trial practice? Does the individual direct a report directly to the elected prosecutor? Are they flexible in the types of cases that they can take? And are they transparent? Is it easy to find out about the policies and procedures within that office? Are they publicly available? Do they speak about this? Do they publish annual reports? Things along those lines. We also look to see how has the conviction integrity unit impacted the district attorney office's culture. Has it made it easier for people to come forward with questionable convictions that they may have worked on in the past? Are people willing to participate in these investigations and be open to the possibility of past error? And then finally, does the conviction integrity unit contribute to a just culture within the office? By just culture, we mean a place where people can feel empowered to step forward and admit error, or at least expose themselves to the possibility of error without fear. And that's really what a conviction integrity unit is about. It's not about blame. It's not about assigning blame, as John, I'm sure, will speak about in a moment, but really looking at where did the system itself err, and where did it err within the prosecutor's office, and what changes can be done in the future to prevent it from happening again. When we look at eligibility cases, so most conviction integrity units have eligibility criteria. They say we will look at cases where the person was convicted within our jurisdiction, often the individual is still in custody, or they had a serious felony conviction. Those are typical eligibility requirements. Beyond that, we also look at things like, do they require the individual to claim that they were actually innocent, or is it enough for the person to say that I should not have been convicted because of the gross constitutional or procedural errors that were in my case? Do they look at the totality of the circumstances, both from what we knew at the time of the conviction as well as what we know now? Are they based on newly discovered evidence, and do they require that evidence to be known to the individual when they're applying or not? And then we're looking at other factors like ineffectiveness of counsel, issues of straight out violations of Brady versus Maryland, junk science, et cetera, to support those claims. And what we're seeing, as you'll see in a moment, is more and more units are broadening their eligibility requirements in the types of cases that they're looking at. So as I said, we have conducted 2 recent surveys, one in 2021, one in 2023, again to dig down in some of these best practices. When we looked at it in 2021, 68% of the CIUs we spoke with required actual innocence, and you can see that that's down in 2023. Now only 36% require actual innocence. What does that mean? It means that they are broadening their flexibility, broadening the types of cases that they will review beyond actual innocence to other things. That might include actual innocence with or without new evidence. And that's an important distinction. To require somebody who is applying to a conviction integrity unit to actually have the evidence of their innocence makes no sense, because people are generally, of course, incarcerated and indigent. They don't have the ability to conduct the investigations. And in these conviction integrity unit exonerations, very often the very evidence that frees the individual was found out through the investigation itself. So it's a problem if conviction integrity units are requiring new evidence before somebody can even be considered. And you'll see that many more are considering legal innocence, consent versus rape, or whether other legal mere conspiracy, mere presence, things along those natures, even issues of intoxication or mental illness. 68% will look at some legal evidence even beyond that, legal innocence beyond that, and now 51% will even look at illegal improper sentencing, as opposed to 34% from just a few years ago. As I said, the other big issue we look at is independence. The best practice that we support is that the conviction integrity unit should be an entirely independent unit. It should not be within the appellate unit, should not be within post-conviction habeas, not within the trial unit. If you look at an organizational chart, it should have its own independent entry. In 2021, 73% of conviction integrity units were independent. Now 89% are. Another best practice is that the CIU should have at least one full-time attorney dedicated exclusively to the work of the unit. In other words, not a half-time position, but one that is actually full-time. In 2021, 22 CIUs had a full-time attorney, and 8 had 2 full-time attorneys, and you can see that that's also grown to now the 28 CIUs that we surveyed had a full-time attorney, and 9 had more than one. When we're talking about procedural transparency, we're really looking at things like how does the CIU communicate during an investigation? Are they disclosing the evidence properly and promptly when it's uncovered, when it's discovered? Are they making their decisions and rationales public, or are they keeping that kind of behind a closed curtain? Do they have policies, procedures, or guidelines which are available to the public, hopefully on a website or at least certainly upon request? And are they reporting out their activity and their metrics, the number of cases that they reviewed, the number of investigations they've conducted, and anything to be able to give the sense to the community what the work of this conviction integrity unit is? Or are they operating kind of what we call in a black box manner, where it's all kind of behind closed doors and really not for public consumption? And that leads to the question of transparency. So again, the best practice is that conviction integrity units should have clear, comprehensive, and easily accessible written policies and procedures, ideally so that those who are seeking the help of the unit will know what is expected of them and what they have to comply with. In 2021, 77% of CIUs did, but we saw that grew in 2023 to 85%. Another best practice in transparency is that they should operate collaboratively alongside defense counsel and innocence organizations. And I know that may sound a little bit unusual because this is an adversarial system, of course. But what we have found is that conviction integrity units that are willing to collaborate and work with defense counsel and innocence organizations on investigations, jointly interview witnesses, have joint interview plans, share all of their files through an open file process, notwithstanding anything about Brady, notwithstanding any other office requirements, but to actually share that information publicly means that they're able to conduct those investigations quicker and certainly with much more confidence from the home community. And what we saw in 2021 was that 72% of conviction integrity units would work collaboratively with defense counsel, and 75% would work with innocence organizations. And now that's grown even further, that in 2023, 81% of all CIUs will work with defense counsel, and in 82%, with innocence organizations. We can make this available for you afterwards, but if you're going to condense the best practices to a checklist, these are a lot of what they are. Is it independent? Do they have their own budget? Do they provide that full discovery to defense counsel during an investigation? Do they allow for pro se applicants to apply and develop those cases and have them access defense counsel through there? Do they have the Brady file? Do they not require a blanket waiver of attorney-client privilege? So requiring attorney-client privilege waiver is of a very big concern for defense counsel and innocence lawyers when working with a conviction integrity unit. It's just not necessary for a conviction integrity unit to access anything from a defense counsel's file immediately. So asking a blanket waiver, especially from somebody who's pro se, is a red flag for most innocence organizations and defense counsel. We, just as Justice Donnelly said, we tried to provide information. This is a website that we maintain for anybody who's interested in learning about conviction integrity units. It's at convictionreview.net. This is part of our work under a grant with the Bureau of Justice Assistance. We have put out guidelines for prosecutors working with underrepresented persons, guidelines for people to work in these collaborative spaces. And this is where we spend a lot of our time, is trying to develop and promote these best practices. So if you're going to look at what is the potential for a conviction integrity unit, and then this will be my last slide, is it's not just about looking back and identifying convictions that were incorrect and fixing those individual cases, as critically important as that is. But if you're looking at the whole system of the criminal legal system, from the crime all the way through prosecution, sentencing, and beyond, if you think about a conviction integrity unit as an opportunity to engage and interrupt error, it actually can interrupt error at any number of those phases. By learning from the convictions, by understanding how the system got it wrong, not individuals, then we can go back and look at the system as a whole and try to prevent those errors from happening in the future.
Thank you so much for that informative presentation. At this time, I'm going to turn it over to Mr. John Holloway, and you can provide your perspective on conviction integrity units as well. Thank you, and welcome. Thank you for being here.
Thanks. Yeah. So I think I'll kind of pick up where Marissa left off with the conviction integrity unit sort of doing that process of evaluating the case and then thinking about where to suggest changes be made. Often CIUs are within the office of the chief law enforcement officer in a district, right? The elected prosecutor. And that when an elected prosecutor advocates for criminal justice reform, they have a lot of impact and persuasion ability and leverage to do that. And so the things that we can learn in the conviction integrity unit process, in the case investigation process, go beyond acts that happened, of course, in the prosecutor's office. We learn about things in the investigation phase. We learn about things in the adjudication phase that may be defense-oriented or court-oriented or jury-oriented, all sorts of things throughout the system. And so what we've seen in the past decade is, it's sort of an incredible growth of what I think Marissa said, 130 or 135 units that are doing the really challenging work of simply adjudicating those investigations. What we're now seeing is units who take that forward and say, okay, great, what do we do to learn from this, not just within our office, but how do we help the police who were involved? How do we help the defense bar? How do we help the innocence organizations to sort of put them out of business, really, and not always have convictions that we can feel have integrity and be proud of. And of course, when you do that, I mean, you kind of can't have a wrongful conviction without an inaccurate arrest, right? That's always sort of the first thing, is that somehow we've made a mistake or an error or gotten it wrong on accuracy at that moment. But then our system already has a whole bunch of checks and balances that are designed to prevent precisely this outcome, right? We have the screening that a prosecutor's office does. We have the role of the defense attorney. We have the rules of evidence. We have the rules of discovery. We have the role of the jury, and each of those is supposed to catch one of these inaccurate arrests before it gets to this phase. And so the question becomes, how do we enable each part of this each of these organizations to get it right? Now, a lot of people, so what we'll do, and what we work with CIUs now to do, is to gather as many of the participants in the original case as we can, now that we have the new information about the case and the innocence, to go back to those individuals and say, help us walk through what you knew then in real time, so we can find those moments where we didn't have the information we wanted to have, where things got confused. We looked at a wrongful conviction where the evidence had actually been, it was a blood test from 1984, and the blood test had actually been conducted as the final day of the trial was going on. So the information that actually exonerated the individual was simply not available at trial. That's actually an administrative communication between the lab, the police, the prosecutors, and the court, because everybody was acting on data that wasn't available to them until afterwards. Then we had all sorts of administrative issues about where that report went, why it wasn't understood, and a whole sorts of things that had nothing to do with malicious intent, right? And so when we do these things, what we always find is that there are opportunities to increase the quality and the accuracy of each part of the system, each role in the system. When the DA's office leads that and says, look, I'm sure some of this happened with us, but we know it's system-wide. Let's all come together and create a more accurate system, which is what we're after in the search for justice and accuracy. That can really be incredibly powerful. It can also be very reassuring to the community, who is very aware of gaps and problems and challenges in the system. And frankly, my personal view is there's kind of a moral obligation of the criminal justice agencies to come together and learn from these events, so that we can improve and the community can have more faith in the job that each one of us is doing. And so increasingly, there is a question in the chat that I think is important, which I'm going to paraphrase, but boils down to, how do you approach this without putting the participants in the original case in a defensive crouch? And I think that's a really important question, right? Because nobody likes to have their work questioned. Everybody worries. The criminal justice system is built on blame, right? What we do is allocate blame all day, every day. That's the mindset we're all in. And so it can be a real challenge to come in and say, whoa, hang on, we're not blaming anybody. This is a complicated system and things happen, and we want to learn from those systems. It's complicated for two reasons. One is you kind of have to reassure people that you really mean it. And two is sometimes you do have intentional actors, right? And that has to be addressed as well. And so what we would do is we would say, first of all, we're going to come in believing everybody acted in good faith. These things happen. There's 4,000 of them that we know of, and almost certainly more that we don't. And we believe that this is 99% of the time a system problem. It may be that we find that somebody did something inappropriate, and we can handle the disciplinary aspects of that outside this process. But even if we have an intentional actor, from a systems perspective, the question is, why did this person think that the best thing to do was something that involved misconduct? And as a system, why were they able to get away with it without detection? So what can we do to increase the ability to detect and deter intentional misconduct is the thing that the system should be focused on in those rare instances where we find it. And when you approach the conversation like that, and you have the support of the DA, and it's an honest inquiry in that way, we find that even across the sort of adversarial line of prosecutor to defense bar, we can make real system progress and growth in that. And we build that process in so that, in my opinion, every time there's one of these cases that a CIU discovers, it should just be implemented so that it's a cultural thing that we do, is we do this sort of just culture evaluation, or sentinel event review as we call it, of the exoneration, to learn from it and make our system more accurate in ways that empower, Matthew and Kimberly and you, Justice, when you're looking at these cases, to be the attorneys they want to be in these cases the first time.
Thank you very much, Mr. Holloway. Very informative. Now we're going to turn it over to Ms. Attorney Kim Corral. I'm hoping that you'll be able to address some of the hurdles that you face when you are representing someone that claims innocence in the state of Ohio. One of the criticisms I've had about the Ohio system is mainly if you have evidence that you claim, if true, undermines the theory of guilt that was used to convict the person in the first place. In Ohio, you are not entitled to a hearing. That is solely a discretionary call by the trial court judge, who is often the judge who presided over the trial and may have formed beliefs about the integrity of the conviction. I'm hoping, I don't want to undermine what you were going to address, but if you can address that during your presentation, I greatly appreciate it. Turn it over to you, Ms. Corral.
Sure, thank you. I think one of the most difficult aspects of making the decision of whether or not to present a case to the CIU or to litigate it, and because one of the questions in the chat was about having to have new evidence. In Cuyahoga County, you do have to have new evidence to apply to the conviction integrity unit. And you also have to have new evidence to litigate through post-conviction remedies in court. And so typically, if you find new evidence for a client, you're in a position where you are determining whether the appropriate course is to pursue litigation or to file an application in the conviction integrity unit. The challenge with both of those procedures, I think Justice Donnelly is what you're talking about, is you have no guarantee to a hearing. And it's important to have an opportunity to put that evidence into the record, and you have to have a hearing to do that. So often it's insufficient to flesh out the materiality of new evidence, of the importance of new evidence, without being able to put it on, to subject it to cross-examination, and so that all of the parties can participate in the litigation of whether or not that new evidence is material. One of the biggest difficulties about conviction integrity applications, one, I think it's unclear to any practitioners in Cuyahoga County presently what the procedure is for conviction integrity. It's been, next month will be 3 years since the board resigned in the conviction integrity unit, citing that they hadn't reviewed a single case for more than 2 years, which means it's been nearly 5 years since anyone outside of the prosecutor's office has any awareness of what the procedure handling conviction integrity unit applications actually looks like. That is very difficult for clients because you cannot pursue litigation simultaneously with a conviction integrity application, which means if you have new evidence and a conviction integrity application pending, your new evidence is not being pursued in court. And the conviction integrity unit process, at least here, does not have any timelines. So there's no indication of if your application's been reviewed, who is reviewing it, is there an investigation happening? And while you may waive your rights, you don't have a right in Cuyahoga County to the information that's produced in the course of that investigation. And so that's an issue both my office has litigated, I know the Ohio Public Defenders have litigated, but the result of that litigation has really recreated or undermined the cooperative purpose of conviction integrity, because if you don't have access to the information from their investigations and you have to fight to get that access, it becomes adversarial again. And so I think what we struggle with in Cuyahoga County is our conviction integrity unit either has intentionally or unintentionally become a marketing objective alone. I have successfully presented claims in the conviction integrity unit, and that was Rural Sailor's claim, which resulted in a cooperative exoneration. And we know he was innocent. I mean, I think all parties agree he was innocent. And there's no question about that. And so that was a positive outcome where I think all parties, both publicly and privately, applauded each other for cooperative work. But I don't think we've seen that in the years since. And, I think listening to Marissa's presentation and John's comments, it's pretty clear that we have a lot of work to do to bring our conviction integrity unit up to the standard of best practices.
All right, thank you so much, Ms. Corral. I'm going to turn it over last but not least to Attorney Matthew On. Give us your perspective on studying this issue and what you believe are things that can improve conviction integrity units.
Sure. I would really just like to zoom out for a second before we get to sort of concrete steps. Put my law professor hat on for a second. We usually like to think of our system of laws as one that is about and tries to create fairness. But in many ways, the law operates rather to create finality and sort of equality of treatment rather than true substantive fairness or justice. And this is why a meaningful conviction integrity unit is really important as an escape hatch for the kinds of miscarriages of justice that we do try to avoid, but we know that are sometimes difficult to completely avoid. When I was preparing for my first criminal trial, I was discussing some strategic considerations with my direct supervisor. And she reminded me of a principle that I think many criminal practitioners, many litigators recite, but sometimes we sort of avoid the ramifications of it. It's the idea that trials are really not about the truth. They're about the evidence that we have in front of us. And so we know that the evidence sometimes does not necessarily directly line up with the truth. We tend to treat the beyond a reasonable doubt standard in criminal cases as an unassailable or an inherent part of our criminal legal system. But there are nearly 10 million criminal cases in this country per year. And so sometimes unreasonable things do happen, right? Very occasionally, that might be because somebody identifiable has made an avoidable error. And of course, in the words of a very wise woman, Eleanor Shellstrop from The Good Place, Nobody's Perfect, but it doesn't have to be a matter of individual misconduct or error, as my co-panelists at the Quattrone Center have mentioned, right? The structure incentivizes the system as a whole to try to treat each closed case as final, even though we know that a human system's accuracy rate cannot be 100%. And I think one of the interesting dynamics here that I want to sort of touch on in generalities is the question of how political pressure plays in here. I don't know if anybody here is sort of the level of obsessive Cavs fan that I am, but one of the folks that I think of when I think about these issues is Sasha Pavlovich, who played for the Cavs about 15 to 20 years ago. He was a good three-point shooter, but he didn't really play defense very much. And there was a day when one of the Cavs reporters asked Sasha Pavlovich, it's like, hey, how are you thinking about the fact that we've seen that your defense is sometimes lacking? And what he said was, oh, my good offense is my defense. And in many ways, this is how a lot of politicians and a lot of elected officials are conditioned to respond to things, right? There's an attack from my opponent. I have to pivot and turn it back on them. And what I think this does is it makes it sometimes philosophically difficult for elected officials to admit wrongdoing or a mistake even, or a miscalculation in the past, and to sort of commit to improving in the future. There are only a few examples that I can think of candidates or elected officials who really sort of owned a mistake fully and sort of, turned that into a commitment to do better in the future in a way that wasn't sort of focus grouped in how we oftentimes see some of these non-apologies or half apologies. And I think that's very relevant to the question of how meaningful is the work that a CIU does. Um, we oftentimes see these elected officials moving in that direction. It's like, okay, I see you having this critique, but I'm going to pivot and move over and try to sort of avoid that criticism rather than own it and move forward. And this interesting thing, I think, is that in talking to folks when I was running for prosecutor, is that my offense is really my defense approach, I think was precisely part of why faith in some of these structures tends to be low in marginalized communities. A lot of folks who are out here see people who are in power who don't necessarily appear, regardless of, how committed they are to getting it right, to choosing justice, who don't necessarily appear with their statements or their actions to be willing to take accountability for some of these wrongful convictions, even in cases that may seem relatively obvious, and even in cases that they may not have been involved in. And we are oftentimes talking in Cuyahoga County about cases at this point that are more than 15 or 20 years old, cases that predate our move to open file discovery here in this jurisdiction. One other point that I do want to note, we talk a lot in general about plea bargaining sort of swallowing the entire criminal system. And the interesting thing is, I think that that's also true in some of these post-conviction spaces as well. Sometimes post-conviction remedies, even if they're litigated, can be treated like a negotiation. And sometimes that does allow for some otherwise unavailable flexibility. But sometimes it leads to outcomes that aren't necessarily going to serve justice either. And I think it's important to recall that when we talk about a wrongful conviction, we're sort of compounding injustice through that wrongful conviction because an injustice has already happened to the victim or victims of a crime. But in addition, you are also compounding that injustice not only by putting the wrong person in prison, but you are also not actually creating true justice for that victim in the first place. And so, sort of negotiating some of these wrongful convictions, I think, can sometimes serve as a further compounding of that issue, right? If the person is innocent, then they should not have to deal with that felony conviction. But there are instances where we've seen conviction integrity units that, try to sort of split the baby in some ways, right? We are not sure if you're actually innocent. And so we might, for example, not oppose your release from prison, but we may not join in a request to overturn the conviction. And when we're thinking about our sort of first principles of justice, I'm not sure necessarily how credible that is going to seem to those members of the community who may not have faith in the system, and whether it actually serves our sort of baseline principles of substantive fairness and justice. And this is part of the reason, I think, why you really want an engaged conviction integrity unit that is willing to sort of really hear out these cases in a meaningful way and to go along with, some of these protections that, have been outlined already that really show folks, hey, this is not here just for show. We are trying to get this right, regardless of how long it takes, even if we think it may have taken too long to get to this point.
Thank you, Matt. We have about 10 minutes left in the presentation, so I wanted to start some discussion and certainly address any Q&A. Domenica, is there any, here's a question. How would the panelists describe the role of legislation in supporting the work of CIUs and IOs? I think that's a great question. And I know that there is legislation pending in the state of Ohio right now that would require judges to, when there is a claim, again, a claim of new evidence that, if true, would undermine the theory of guilt, um, that the judges would, it would no longer be a discretionary call. They would be required to have that hearing. And interestingly, I spoke with a prosecutor this week in advance who was going to participate in watching this and raised the point from a prosecutor's perspective that I can understand, especially during recantations that take place often years after the original trial took place. And we all know that prosecutor cases don't tend to get stronger as time goes by. Um, uh, and my response to that was that, you know, recantations should be looked at with skepticism because the person testified one way under oath at trial. But there's no database that has any evidence that would support how many recantations are true or false. And that can only be tested, in my mind, having been a trial court judge for 14 years, in an open hearing where both parties, the innocence advocate and the state, who may believe that the original conviction maintains integrity, has the opportunity to cross-examine that person and make arguments as to whether that recantation truly undermines the integrity. That's legislation that is posing right now. I know the question was in general, but if we could hear some response from the panelists on how they could support CIU integrity units in this regard.
I can jump in a little bit on that, Mr. Justice. And so, in terms of legislating conviction integrity units, it's really not a great idea for a lot of reasons. One, some offices are just far too small to be able to accommodate a conviction integrity unit. And if you're in an office where there are 5 prosecutors and who have been there for a long time, they know every case that has come through. You can't take them out of that potential bias for reviewing cases, because one of the clear best practices is any attorney who is involved in the trial or appellate process of that case should not be involved in the review. So it's almost impossible for smaller units to do. But also for these legislatures that are looking at it, it's the better practice is to fund them. When a prosecutor wants to have a conviction integrity unit, have funding available for them, because they're having to make do on resources that are already stretched incredibly thinly. And then finally, in terms of the hearing, so one thing that conviction integrity units do pretty regularly is if they agree to relief, if they do agree that the individual is innocent or wrongly convicted, and they support relief, they will go to court and submit findings of fact and stipulated facts and tell the judge we don't have to have a hearing because we agree. Most state post-conviction statutes only require a hearing where there's a disagreement on the facts. Well, there's an agreement on the facts, there's no hearing that's necessary. So a court can accept a concession of error from the prosecutor without even having to hold a hearing and not extending the process even further.
If I could just address for a second, you talked about, Justice Donnelly, that recantation should be looked at with skepticism. You know, I do think to some degree, and there's a lot of case law that says that they should be treated with grave suspicion, I think is the language. But when
Yeah.
you're talking about a recantation, usually the person recanting is doing so at risk of criminal prosecution themselves, and their credibility is fixed because they've now signed an affidavit, and an affidavit is a sworn statement. So if we look to their recantation calls their credibility into question, and it shouldn't be automatically perceived that their credibility is in question only with regard to the statement they made that's favorable to defense. And when we treat it that way, I do think it undermines the court's position as a neutral arbiter. If we assume that the recantation is the lie, that the lie comes when there's the most cost to the speaker, then we're undermining the neutrality. And rather, I think when there's a recantation, which is made at great risk to the speaker, in Cuyahoga County, a recanting witness in a case that I handled was just charged with perjury. And so her recantation came at great expense to her, where her original statement came with significant benefit. but her recantation was viewed with grave suspicion, and only through a hearing can we put those two statements and the credibility of those two statements against each other, where both parties can cross-examine them. So I'm kind of on the opposite, not that it should be treated with grave suspicion, but that it should be treated with the utmost seriousness and automatically be given a hearing, given the risk to the speaker when they made it, and given that their credibility is a fixed is a fixed element. So their recantation undermines equally their credibility now and their credibility of their statement at the time of trial.
Right. I certainly didn't want to equate skepticism with grave suspicion. I've seen that jurisprudence over the years, and I've always disagreed with it because there shouldn't be a presumption. Some recantations may have merit, some may not, and even a recantation at a hearing that proves not to undermine the guilt of the theory of guilt. Let's keep in mind that every prosecution is nothing more than a theory of guilt. Okay, it's a theory of guilt that may be a strong theory or a circumstantial theory or a weak theory, but it's nothing more than a theory. The prosecutor doesn't know, and unless the defendant confides in attorney-client privilege associations, the defense attorney may not know of the truth of what happened. So, but my to give both sides an opportunity, I think prosecutors should welcome the opportunity for hearings. Unfortunately, we haven't focused on another stakeholder that is important in it, and that is judges. And we have motions for new trial alleging new evidence, not only in Cuyahoga County, but throughout the state of Ohio. I've seen this dynamic take place where someone files a motion, claims to have new evidence, the state opposes it, which is fine, and it's their right to do so, but they languish on trial court judges' dockets with no future event date, sometimes for years. This is a problem that I think legislation has to take place. One other thing before we conclude, how do we change the culture? We've all heard of internal affair units within police departments, and police departments don't tend to look on the police officers that serve as internal affairs. I look at conviction integrity units as something akin to that. How do you change the culture and, as you mentioned, Marissa, at the beginning, have a truly independent conviction integrity unit with prosecutors who actually work side by side in the office? How do you accomplish that?
Well, I'll pop briefly on that, but I'm sure others have more informed opinions. Usually what we've seen work is where the elected prosecutor stands behind the conviction integrity unit and says, this is how we're going to do things. This is what's going to happen through this office. It sets the tone through the office of how important that is and where it means. And again, looking at the independence of that unit, is it an independent unit? Does that person report directly to the DA? Are they involved in other policy-making decisions of the office? All of those set the tone within the office that this is going to be a priority and that we are going to take this seriously. So that can go a very long way of getting rid of the kind of trying to attempts to undermine a conviction integrity unit or just not go along with what they're trying to do. It really does kind of come down to how strong is the elected on these issues and how vocal are they.
All right, thank you. I'm looking at the clock. Domenica, I believe we're at 1 p.m. Is that correct?
Yes, thank you so much, everyone, for keeping on time. You